Good evening, everybody. Welcome back for another episode of Reasonable Doubt, brought to you by the Harris County Criminal Lawyers Association. I'm your host, Jimmy Ardwan. Across the table here from me, as always, my co-host, Julio Vela, looking sharp tonight. How are you, my friend?
Very good, very good. Anytime I got a rising star, or a star who is risen.
Kind of appropriate post-Easter.
Right, because of the whole, like, Jesus. We had a Jesus show last week, remember that?
We did.
And my good friend, mentor, and past president and host, the one and only, TB Todd DuPont. It's a good day.
Who dressed up for us this evening? Let's see.
Hello.
You put Todd put on his Thursday best to join us, ladies and gentlemen. But yeah, we're going to be here with the next hour talking with Todd and Wade. We've got some great topics to talk about. We'll have Twitter up all night so you can post your questions and comments to us at HCCLA_TV. We'll also open up the phone lines. We say halfway through the program, but we don't really mean it. If you call in, we'll probably take your call. So call them when you want. If you want to get on the conversation, 713-807-1794, and we'll get your questions and comments right here on the air. Guys, interesting week here around the city of Houston. We've had a lot. How should we say this? I want to talk about this new district attorney's program because it's posted all on social media. Kim Ogg herself came out, did a nice little puff piece video on it, and Julio, you said you put somebody on it today. In fact, what is the actual name of it?
So the name is Clean and Green. I wonder if they sat around a table, much like this, and said, "Hey, we should call the marijuana program Clean and Green. That'd be hilarious." And then somebody said, "That's a good idea. We should kind of mock it a little bit and put them on it." The program's called Clean and Green, and essentially, individual post-charge. So for some reason or another,
So after they've been charged,
they're charged and in court. They're arrested,
okay,
bonded out, or unsecured bond, or PR'd bond out. Now we have a court.
Which begs the question, why weren't they issued a summons?
So so it's post-charge. The pretrial intervention is, or the first chance program for marijuana, less than a big old sack. You should be getting an intervention, so to say,
right?
Or the first chance program. You take a class, it's case dismissed, you call it a day, and you don't even. There's no charges filed. There's no supposedly there's no record, and it's over. And you can get the first chance over and over and over and over. However, what we've been seeing is individuals coming to court who are charged with marijuana, who by all accords should have been given the first chance program.
Or the second chance program.
Or the second or third or fourth, fifth chance program. But they were arrested anyways, and now they're in court. And for whatever reason, they weren't offered this first chance program, which we saw a piece by Brian Rogers, are that there's certain agencies that are not complying with the first chance program, and they're still arresting people or filing other types of charges. So for whatever reason, this individual is back in court on
That's the answer.
On a marijuana charge, who should have been given the first chance program or second chance or third chance or fourth chance program. But they've been arrested, they've made some sort of bond or have been given some sort of bond or are in court. The program requires the individual to get a 60-day reset, to pay $240, to complete 6 hours of community service, I suppose cleaning up the bayous or cleaning and greening, whatever that means.
I thought it'd be brown and green.
Brown and greening, right?
I really kind of...
Not a lot of green down by the bayou.
Not a lot of green, right? Coming back to court, so you complete your program, you pay your $240, you clean up whatever you're going to clean and green it. Probably high when you're doing it, or not, whatever. And you come to court with a certificate saying that you're done with the program, and at that point, the district attorney hands you a dismissal. And at that point, you can apply for an immediate expunction of your possession of marijuana charge. Now, it's different from the first chance program in the sense that, number one, you're arrested. Number two, you have to pay a $240 fee versus the first chance program, which I believe is $100 or $150.
I think it's $130.
$130 fee.
To the DA's office?
Yeah.
To the district attorney's office. So this one's a little bit, it's more expensive. And there's a record of your arrest, there's a record of a charge, and so that individual is going to have to file an expunction in Harris County. It's $292 to file the expunction, and then you go through that process and such.
Which makes no mention of attorney's fees.
Right, which makes no mention of attorney's fees. That's correct. So I put someone on today. Nobody knew anything. So
How'd you put him on? I mean, if nobody knew
Dan-
anything, how did you put him
Vogue.
Well,
Like,
so it's a brand new program.
Yeah.
I think they just rolled it out a couple of weeks ago, and
I just saw the video on social media today.
yeah,
Well, I think it's yesterday is when she.
yeah, I think it started, but they were
My
starting
timeline's
to.
behind. I've got a lag, I guess, in my
We do.
timeline.
They were starting to send out the informational packet to all the prosecutors. I think like maybe 2 to 3 weeks ago, because I had a prosecutor show me one. We were talking about it after court one day, and they were kind of griping about it a little bit because it also works for the people. So we've been, since Kim Ogg took office and we got that for the first chance program, there's been all these people who have been put on it. But there's also been a lot of people who haven't done their part on it, and the DA's office is finally coming around and filing charges on the people who didn't do what they were supposed to do. Because that's part of the deal, was if you do this, nothing's going to happen to you. But if you don't, we're going to file a charge. Right, JB?
my guy today, yes, that has been the historical pattern, but my guy today wasn't offered the first chance in the first place.
And that's the other situation. So now, but they're offering this program to people like what JV had, and now also to the people who messed up or refused to do their first chance program. And now they're coming in and they're getting the clean and green, which a lot of the prosecutors are like, well, they're getting like a second or third chance out of this because they messed up the first chance program, and now we're going to give them clean and green.
If Kim Ogg decides that's how she's going to do it, that's how she's going to do it.
Right.
What's the 30,000-foot view of this?
The 30,000-foot view of this, at least from this moment, is that nobody knows how to put someone on the clean and green. And
Other than you doing this.
other than you just doing it. So today, for example, this is the process. So anybody who's going to go on the clean and green, any attorneys or defendants, this is the process.
Attorneys are going on the clean and green program too?
Well, advising individuals on the clean and green.
Is it part of your discipline?
So you have to email, you have to make a phone call to this number, not the defense attorney, but the prosecutor has to do it. You get a date that are available for clean and greens, a range. You have to agree to a certain date. And they say, okay, great, we got it for April 20th, clean and green. Is that 420?
420.
So I put the guy on today was for 420. That's hilarious.
You did that
Anyways,
on purpose, didn't you?
I didn't, but maybe I did subconsciously.
Happy accident.
Yeah. So you got to call this number. The district attorneys have to call this number in court when they have time. They call it and they say, hey, we got a date range of April 19th through the 24th available, for example. Your client needs to pick one. So then you go with your client, you say they got a date range between the 19th and 24th. What do you want? Client says 420. Great. You fill in 420, or you tell them 420, and then you wait for this department somewhere that sends an email to the district attorneys for a completed contract, much like we do with DWI PTIs, pretrial interventions. Mm-hmm. District attorney receives the contract. They have to print it out there in court. You print out that in court.
So it's a PTI.
It's a PTI. You get it. You fill out all the stuff, all the information. They sign everywhere it needs to be. It's $240. And then The district attorneys keep the original. Your client keeps a copy and shows up at the designated time and place and cleans and greens. And then you get a reset for 60 days. They come back to court with the certificate, and at that point, the district attorneys will hand you the dismissal.
Well, that kind of highlights what Wade just said. There are folks not abiding by their agreements, and so therefore they're showing back up to court, not completing their contract.
Which begs the question, if they're not going to complete the first chance program,
Are they?
are they going to complete the clean and green? Additionally, with the clean and green, it's post-charge. So that individual has an arrest, a court appearance, bond. So there's paperwork. So that individual has to file an expunction to expunge their record.
Is there a waiting period assigned to the clean and green
Well, currently,
built into the system or any the contract you read today?
you have to call them to tell you what dates are available. So there is a built-in waiting period. I believe that because
The
of,
expunction.
oh no, not for the expunction. You
So
can
they're not making you wait 2 years.
no. Well, no. At least now they're not. I don't know if you pick up a charge from the time that you do the clean and green, and maybe you pick up another charge. At that point, the district attorney is going to oppose an expunction. Is yet to be seen, at least in my opinion.
Interesting.
I had a guy. Let me do a quick anecdote real quick.
Oh, okay.
I had a guy.
Let's see how quick it is since we didn't get through the explanation of clean and green so quick.
And no, well, this is the cluster that's down there today. I will give hats off that everybody was very nobody knew what was going on, and so everybody's very cooperative. But I had a guy, they offered him the clean and green. That's awesome, clean and green. I was in the middle of putting him on, and then they said, "Oh wait, this guy, he has an open warrant for murder." Right? And I was like, no, clean and green, I already conveyed it. We're doing the paperwork. Wait, what do you? And so, I'm clean and greening that out of there,
Why are you bringing up old stuff?
Why are you bringing up murders and stuff? It's clean and green.
Man. So scrolling through here, I'm on Kim Ogg's Twitter page, and 12 hours ago, she posted an alert. Don't get scammed. Apparently, scammers are posing as Harris County District Attorney's Office officials to try and con people out of money. Who knew?
Wow.
Yeah. Callers demand immediate payment and threaten the victim with jail time. These callers may seem legit, not legitimate, legit, because the con artists often have the name, address, case numbers, and even social security number of the individuals. Reminder, the Harris County District Attorney's Office will never demand money from you, except in court with your attorney.
Right.
Fix
Except
it safe.
court over there on Prairie and Caroline, where they demand that you deposit their money and such.
Yeah.
Yeah, or they have on the check fraud division, when you have a case with a hot check, you'll have the restitution will include the amount of the check, the usually $30 or $60 from whatever the bank charges were, and then if you look at the itemized list, there is a DA fee of like $30. And I asked the prosecutor one time, what is that? And he said, I don't know. And I said, well, let's be honest, that's y'all's collection fee. And he said, I'm not going to comment to that. But it is.
And handling.
I can, Kim Ogg is doing these new things. I tip my hat to her. I think the Houston needs to be beautified. However, the communication down the chain has been problematic. So, for example, there's no offense reports being printed down at the jail anywhere anymore.
Yeah, I saw that announcement come out. So apparently they're not going to be bringing physical files to the jail dockets anymore. And I guess that's just, they're probably not going to be bringing physical files to even the courtroom anymore, except on the days that they have trial.
Here's what's worse, and Kim, I'm speaking to you too. apparently there's a missive where you cannot write criminal history.
Right, I heard
Kim
that too.
wants nothing wrote on the jacket. Okay. At intake, of course, the prosecutor that's working intake receives a charge, reviews NCIC, TCIC, writes criminal history for the prosecutor to understand what person they're dealing with in court. But of course, the defense lawyer reads the same information so we can understand and look at. It's very problematic, Kim, when it's not written on the jacket and we're asking about bond conditions or trying to figure out, talking about how to deal with issues with a person in court that particular day. Mind you, we're in jail dockets, everybody's rushed, that there's no kind of list that at least gives us a ballpark of who's been to prison before, what the criminal history is. The jacket, somebody made that jacket for a reason. For years, I've been a lawyer 20 years. They've written out criminal history there. We all kind of reference it. Kind of sucks when criminal history goes on the back, right? Right? And then there's two TDC trips on the back of that. You're like, oh, wow, okay. However, the idea, Kim, for you to tell your people not to write out criminal history is making our jobs harder first. And of course, the printouts in there, but typically the intake process, when they're creating that file, they write it on the jacket. Second, with the notion that there's no writing of anything on the jacket, there's no dim summary on the jacket, which takes longer for the prosecutor when we're arguing bail or anything's in front of a court that's already stressed and out of time.
It's the same thing. There's been, from our understanding, there's two directives, nothing written on the jacket and no offense reports.
I hadn't even got to that. And you're right, and I won't, but the point is the line prosecutor has to have an offense report.
They have to. And the directive was, at least in the misdemeanor jail docket, was, okay, so no printouts of offense reports. You can look at the offense reports when on the portal, but you can't get to the portal and look at your offense reports until you're attached. Mm-hmm. But when you have 50 lawyers in the jail docket slamming the court with appointments and slamming the court with notices of appearances, you're not going to get attached to that case and through the system until the next day.
Well, and I think this is part of the growing pain process we're going through with the conversion to a paperless system, right? So, I mean, there's you can't just do it all at once. This is kind of like turning the Titanic, right? So, but I think it's going to be, and I don't know this for a fact, what happens when you file, for instance, a notice of appearance with the e-file system, okay? So for instance, in federal court, you go onto the ECF system, you are attached immediately as soon as you file it. Now, I filed a couple notices of appearance in state court, and I think there's a lag time. So you
I know the answer.
Huh?
That motion sits until you approach. The answer from the clerks are, in Harris County, is it's the same as if you brought a paper motion to them. They'll receive it, so electronically they've received it. They're not going to act on it until you say, can I approach the bench?
See, I was told differently. I filed one, and I got it kicked back, and they said you didn't include your SPIN number on it, because I'd just done the typical signature block that most of us do that only includes your bar card number. So the clerk's office kicked it back to me, and they wrote a nice little letter, said, put your SPIN number on there so we can attach you. So But I still think there's a lag time. I don't think it happens immediately.
It doesn't.
It's not
See,
instantaneous.
And I've had
doesn't.
a different experience
Yeah.
because I did a notice of appearance just on my letterhead with a, actually not on my letterhead, but just a regular notice of appearance with my signature block. Did not have my SPIN number on it. And I filed that and a request for discovery at the same time. And it all went through. Everything, I got attached. I don't know how quickly I got attached. I agree with you, there is a lag time.
Yep.
But it didn't get kicked back to me. I didn't have to approach anybody. It got done automatically. So there's a lot of inconsistency
Yeah.
with.
Well, it's
the
because you've
process.
got.
Perhaps that's growing pains.
Yeah, it's part of the growing pains, but you don't have a standardized system. You know, you've got eFile Texas, you've got the Harris County District Clerk's office. They're not merged together. They're basically eFile Texas is a vendor that provides this. It's not like the federal court system where ECF is the federal court system. So it's instantaneous. You file a motion, you know, everybody who's attached to the case gets a copy of it. The problem is you get a case, okay? Let's say you get just a DWI case. You go down, you get it, your client comes and hires you. It's been filed. They've already bonded out, they've done that. So let's say they come maybe a day or two before the first court appearance. You go ahead, being the good lawyer that you are, and ahead of the 8 ball, you file your notice of appearance. You go ahead and prepare your discovery requests and all your requests. You file them. Here's the problem. You have no clue who the prosecutor is.
Right.
You have no clue who that is assigned to.
Big
I would
problem.
serve the chief of that court.
You may not know who that is.
We're subject only to their list.
Exactly. That's
Right.
what I'm saying. And the lists have a lag time in getting out. So you've got
And
a problem.
change often.
Right.
Right, and they change often.
The best
And
thing you
so-
can do is make a phone call to the DA's office and ask the receptionist who is the prosecutor
Agreed.
that's going to handle this particular case in this particular court, and they give you that person's name. And then you got to hope that Harris County's done pretty good as far as having individual prosecutors' email addresses for their discovery or their service contact uploaded to the e-file system, but sometimes I've gone in and not been able to find a particular prosecutor.
Well, and the problem is that what really should happen at the DA's office level is they should assign an email address for just a generic email address that says Court
Right.
1 prosecutors at Harris County District Attorney's Office.net.
Right.
Okay.
So I have a case in Travis County, and that's how they do it. They have like a discovery coordinator or whatever with each court, and so when I sent off my discovery request, it went to County Court 8, yada yada, whatever their tagline was.
The people who are suffering now, and it might very well be growing pains, are the people who are accused of crimes. There are many things that we have to argue that day. The second that individual is given to us or that we're hired on, we have to have access to the offense report, to all the identifying information with the report. Oftentimes, we don't know anything other than what's in the police report regarding phone numbers, names, addresses. If we're going to go up and argue about an individual, so an individual is charged, let's just throw it out there, assault family member, boom, he's going to be held at a no bond or a high bond until a magistrate's order for emergency protection is provided. Oftentimes on that first setting, I'm able to look at that police report previously, look at the police report, find out who that complaining witness is. Hey, we got to go talk to the judge about this magistrate's order for emergency protection,
Of course.
or bail conditions, or anything that's regarding this individual.
Judge, he has a clear criminal history.
History, all of that.
Please.
Well,
Yeah,
we
but
don't
if
get
that's not written on a jacket, we get it.
We get nothing. And that individual, guess what he gets that day? A reset. And if he's in jail, that reset, because you can't, if you're in felony court, that reset's going to be for a month. If you're in misdemeanor court, that reset will be for at least a week until that particular court is back on the jail day.
Yeah.
But there's still not going to be an offense report in the file.
No.
Nope. They're going to be held in jail. We can't, a lot of times, I have to subpoena or put out a discovery order or a motion to preserve within that day or two. And
If you don't have an offense report.
if I don't
you
have an offense report, how am I supposed to do it? DWIs, you have 15 days from the date of your arrest to challenge the suspension of your license. Yeah, I do ALRs for people for people who are appointed and in jail and who can't afford it too. I do that as part of my duty.
And the reason it's important that you're pointing that out, JB, because I don't think many people realize this, the ALR is an administrative hearing. It has nothing to do, not really, with the criminal case. But when you get appointed to a DWI, if someone's hired on a DWI, they're going to roll that into the fee. It's going to be part of the job.
Hopefully.
Hopefully. If they're doing it right. You're exactly right, Todd. But as an appointed attorney, the courts will not pay us to do that ALR hearing, despite the fact that that is one of the only situations in Texas criminal justice where we get an opportunity to cross-examine an officer under oath before a trial.
Right. And without that information, those people lose. And a lot of times, with no police report and I'm not attached yet, if we're talking about little misdemeanors, for example, or even mandatory probation cases in felony court, mandatory probations, less than a gram kind of stuff. If there's no police report, there's no deal. And if I'm not attached and can't argue bail, I can't argue, and the district attorneys won't offer an offer without us knowing what's going on, it'd be malpractice to start pleading people without
I'm asking
at least a view.
I'm asking Kim Ogg and at least John Music tonight, respectfully allow the intake prosecutor or their prosecutors to do what they've done for years, the way that y'all have practiced law in Harris County for years. Let them write on the jacket the cursory information that when we're at a bench talking to a judge that doesn't have a lot of time to hear us, we can reference quick information. And secondly, I'm asking that, okay, if the idea is to save paper, we'll print out our own offense report, but at least allow one offense report to be printed in the state's file.
We have to have that.
I agree.
So we are literally going to clients, paid or appointed, saying they come to us or we meet them on the first time. They've been arrested. They want to talk about their case, and they say, "Well, what's going on?" And you say, "I don't know. I got your name, I got your cause number, and I got a blank jacket with nothing. I can't tell you anything." So you get reset. That is never okay. But it could be understandable in a situation where you already know that this case is going to take a year. However, what about all those individuals who are charged with crimes where they could get out that day too? You know,
That's the rub.
What about that? What about the driving while license invalid? What about the trespasses?
That's the rub.
And now, with the clean and green stuff, it's on both sides. They're offering clean and greens to people who got pending murders, which, okay, as a defense lawyer, it's not my problem, but it works both ways. Like, how are you supposed to do that? It's a big problem, and it needs to be solved, and the people who are hurting are the people accused, presumed innocent individuals, presumed innocent, because not everybody's innocent, okay? Not everybody's not guilty, okay? They're not. However, without that due process and that process, guess what? The Constitution provides them this protection, and they shouldn't be held back or put in a disadvantage in any sort of way from any step of the process.
Right.
Especially from two defense lawyers who now work for the DA's office.
Right.
Who know our issues.
The other issue that's popped up is the district clerk's office. And Chris Daniel, this is for you. Here's our problem, man. and this is what I have found, it's a growing pain. Fine, it's a growing pain. Whatever. You might think whatever. However, for example, I have individuals where an order to remove their interlock, their case is over. So when you get accused of DWI in Harris County, you get the machine. That's what happens. You got to blow in it. Or you get the portable machine, you get the machine in your car. Their case is over. They've pled, they've done their time, or they've agreed to whatever plea bargain it is.
Dismissed.
It's got dismissed, for example.
Or you went to trial.
Or you went to trial and got acquitted. There's a lag time of about a week from orders that are being entered electronically to the time that you're able to actually receive that order. So, if you have a motion to return property, for example, or if you have a motion to remove the interlock machine because you got acquitted. I had a trial case recently that was dismissed because they couldn't make their case.
Can they make a copy of the order?
Only
Give
if
it to you?
only if they like you. Only if you have a special in with that court, they'll make a they'll print out a copy of an order, for example, removing your breath machine, even though your case is already dismissed. If you're not special in with that court, you're not getting a hard copy of your order to remove your interlock. But your payment to renew that interlock is due tomorrow. And you're sitting there like, my case is dismissed. The government has no restraint on me whatsoever anymore. It is over and done. And I need this machine off my car before I have to go pay them a couple $100
It seems to me you
to
would
remove it.
want to demand a copy of that order.
If you're
So
yeah.
the way the process works with this new e-file system is, let's say case is getting dismissed, and you're going to get the interlock removal. That prosecutor is going to pull up on their computer there in the courtroom the dismissal. They're going to electronically sign it, and they're going to send that to the clerk.
In the same room.
In the same room. And the clerk is then going to receive that, and they're going to put it in this little electronic queue for the judge to sign. And then you go over to the clerk and you say, hey, we also need the interlock removal order. So they pull the clerk pulls one of those up, puts it in the queue.
And the judge goes to lunch.
And then,
I had a case. I'm about to do an anecdote about that.
yeah.
You're full of them.
So
Got plenty.
the judge then, when he gets a moment, he'll go through his queue and sign a bunch of stuff, or she. And then that goes back to the clerk for whatever the clerks have to do at that point. Like you say, Julio, the clerks, because we are going to this electronic system, it's not supposed to have paper. Most of the clerks will not print out copies unless, as Julio says, you're in that court a lot, that clerk happens to like you, you go over, hey, can I get you to print out a copy of that for me? Occasionally
So
we'll do that.
my client can take that to the interlock person and say, let me.
Yeah, but see,
Right.
I mean, this is part of the problem is you need a system that as soon as it's signed by the judge, he hits a button, it's entered, and you get a copy of it in your email.
Well, that's why they had.
That's what should happen.
It's not triplicate. How do you say 5?
Oh,
Triplicates.
Quintuplet.
it's not the
Couple of-
5-page carbon copy that it used
That's
to be.
better.
Right.
Right.
Yeah.
I had a guy recently.
Because they get a copy, they take that to Burns and they take it off and hello, goodbye.
Unless you don't get that copy, that person.
But you know what? The easy solution on that is electronic service of everybody. So when the order is entered, a copy goes to the defense lawyer, that goes to the prosecutor, and oh yeah, it goes to the interlock device company. Why can't they be somebody who gets a copy of what's going on?
Agreed.
Shouldn't they be person who's? I mean, they're an interested party in the litigation. They should be getting copies of the court.
They
order.
send the court notification
That's right.
when there's violations.
violations.
Yeah,
of the
why
interlock.
can't the court send something back to them?
Yeah.
I had so
Is
recently.
that a Chris Daniel issue?
It's a Chris Daniel issue, and here's the Chris Daniel issue.
Which he'll address. I promise. I think he would.
He will.
I think he would, but I think the problem is he's powerless to do anything. He doesn't have the resources to do it because you've got a situation where the system is set up as such that you have this vendor who's doing the electronic, who's basically taking in all the electronic filings, and you're not on the same platform. So you've got two different systems. And I think if he could do it, he'd love to do something that is a single system, where either for the whole entire state of Texas, or even if Harris County just had, one single system that populated everything. But, I mean, we're in a situation where
the folks in Harris County are smart enough to do that.
They are, and we got tons of people who could do it. And we got a phone call. I want to get a phone call in right now.
Wonderful.
So
Great.
let's jump over to the phone lines and take our first call of the evening. Hello, thanks for calling Reasonable Doubt.
Hey guys, it's Justin. I wanted to see, I like the conversation y'all are having about.
Well, we aim to please you, Justin. That's what we do.
Yes, well, thank you. The conversation y'all are having about changes and things like that. I don't hear necessarily anybody saying that change is bad. We need to go back to the old way of things. But I'd like to see if the collective four of you all have ideas of other changes that could be made that might make more long-term kind of, I don't want to sound too hippy-dippy, but kind of cultural changes in the office. I know I'd spoken with Wade earlier in the week about why the DA's office has this hierarchy of ascension. You start out as a misdemeanor 3, then you go do a JP rotation, then you come back as a misdemeanor 2, and then you go do an FCLD rotation, then you go back as a misdemeanor 2, and then you go
that
to felony
rotation,
3.
Justin, that rotation is not alive today. That's non-existent if you ask regular prosecutors today.
Well, I'm just curious what other changes could be done to possibly make more change. I don't want to keep using the word change, but are there any other ideas that you guys have for things that could be done differently, not just in the clerk's office with e-filing, but anything else like that? I'll listen to all the other comments off air.
Look, I mean, you're going to have your gripe with every administration that comes in, right? I mean, everybody had their gripes with Johnny Holmes. Everybody had their gripes with Chuck Rosenthal. Everybody had their gripes with Pat Lykos. Everybody had their gripes with Mike Anderson, and then Devin Anderson. And
don't forget Ken Magidson.
Well, and Ken Magidson, that's right, for the time he was there. And the foolish thing that a lot of the defense bar bought into was, oh, we're not going to have any problems with Kim. Well, look, we are in an adversarial nature. She's going to do things how she wants to see them done, okay? She's not going to do things the way the defense bar wants it done. They're a prosecutor. And you can't sit here and say, well, Kim, we think you should do it this way. Well, she got elected into office.
I
know you told her that.
Twice, and I've asked my friend Joanne, look, no matter who's at the helm of the DA's office,
you're going to bitch about it.
They're not going to do anything the defense bar wants us to do.
No.
First, even though conceivably everybody at the top end of the DA's office right now has either been on the show,
right,
or a past president, or incredibly involved with the defense bar.
Look, you could take somebody.
This is the truth.
It is, but look, you could take somebody who has been a defense lawyer their entire career, that has never prosecuted a case. I mean, I've never been a prosecutor. If for some reason I fell and hit my head and decided to run for office and ran for district attorney, I hope y'all would punch me and prevent that from happening, because it'd be the stupidest thing ever that I could do. But I guarantee you would be on this show telling me all the things I'm doing wrong, because it's just the nature. It's just the nature of it, and that's what makes our legal system great, is the fact that we're here debating what the policy should be, and there's always going to be give and take, because the prosecutors want to see things done their ways, the defense bar wants to see things done certain ways. And so there's always going to be this natural butting of heads. Even if you, like I said, you take the person who's been a career defense lawyer and you put them in that position, they've got to now shift their thinking and the way they want to do things, because their job duty and their responsibilities have changed.
Most of the felony prosecutors I deal with aren't happy with their situation. That likely is a involves a number of situations: morale, policy.
Politics.
Correct.
I mean, look, let's be honest. Politics is the big driver.
I'm trying
You've
to
got
be straight honest with
Yeah.
all of us here.
yeah.
But we still have to work together.
We do.
Every day.
But I feel like the majority of they can talk about, you can talk about, well, we're upset because, you know, this isn't the right thing to do. We're walking on eggshells. We don't feel like we can make decisions or do something without being scrutinized. I don't know. I just work here. With standard line, you get a lot of things. But the reality is, you walk in that building every day, and you can cut the tension with a butter knife. Okay? Because it is so bad right now. The tension between the Republican prosecutors, ADAs that are still in the office, and the fact that the Democrats have control of that office, there is so much tension right now between that. And I really feel like that is creating so much friction and is causing a lot of the morale problems. You've got a Republican Party who is who's hanging on for dear life right now, and may get completely just gut punched in November. I don't know. Maybe they recover, but honestly, this stalemate that's going on, I think that's creating a lot of the problems.
Well, let's not also forget that not only do you have this political tension where you've got some leftover, well, let's just say what it is, Devin Anderson followers that are in the office that are still there,
Right.
but now having to work for Kim Ogg. And there's that political tension, but you've also got the political tension between the DA's office and the majority of the judges,
Yeah.
Yes, absolutely.
which also puts those prosecutors in an even tighter spot because they don't see Kim every day.
No.
They don't necessarily see their supervisor every day, whoever that might be, but they do see that judge every day. And
But see, the Republicans have their own problem too, because they have a split in their own party when it comes to criminal justice reform.
sure,
Okay, and that's also causing a significant issue. I mean, look, they primaried some of their own in the election this year.
Yeah.
Okay, and there is a real problem there too.
And here, let me add two more to them. Some of the brass of the DA's office should come to court and actually see what their line prosecutor has to do.
Mm-hmm.
And I believe HCCLA has asked Kim Ogg to come to court. I'm asking you to come to court. The problem with coming to court is if you go that one day, it might be not a real sample of what you see, but by and large, I'm not going to say most, there are prosecutors are fearful by missives that are sent down from the top that they're going to lose their job at any given day. And it makes for a terrible place to work for them. And trust me, I'm a defense lawyer, I have been for 20 years. I'm going to advocate for my client the best I can. I might reach a deal with the prosecutor who says, I want to do this, but I'll be fired if I do. And so I can't, which is incredible.
Right.
This is incredible.
Yeah.
And that happens all the way down from felonies to the misdemeanors.
all the way down to misdemeanor.
All the way down. And if it's not them worried about being fired, it's I would do this, but this judge ain't in a million years gonna do it.
Yeah.
When the judge right across the hall or upstairs or on another level, floor would do it in a heartbeat.
On another show, we're going to lambast those judges because it's silly. They wouldn't take a deal the state and the defendant agreed to. Why would they get involved and bust a deal? I guess, to me, that's another show, but Lord.
That's a very long conversation.
that's a 5-week segment, right? But
Well, the short answer is because they can.
Yeah.
on a misdemeanor, right? Like you're talking, I'm not giving him 5 days, I'll give 30 days. Like, really?
Yeah. Well, why? Well, because
I can.
Because I can.
That's exactly why.
And the district attorneys are offering something.
Judge, we have an agreed plea for time served.
No.
I'm not taking it. What?
For a driving while license invalid? Are you serious? All right.
The ones that irk me more than if you have, even if you the time served plea or some sort of plea where you've got that worked out, but when they refuse the pretrial diversion.
Right.
And I'm not talking about a pretrial diversion like.
But we keep coming back to this.
Yeah.
And we keep coming back to.
It's an ongoing problem.
Well, but it's not. It's the problem is the DA's office should dismiss on the front end.
So
they're creating the problem by wanting to do this whole long reset and have probation supervise the pretrial intervention. Cut that BS out.
You're absolutely right.
Cut it out.
However,
that ends the debate right there.
I have recently learned though that so a lot of the counties outside of Harris County do that, and we've talked about
a lot, like out of the 290
Yeah.
counties in whatever 294 counties in Texas,
But
what I
293
have
of them
learned,
254.
but what I have learned,
253 of them do it that way.
yeah, Jimmy, what I've learned though is that the ones that do that, there's a catch. So in Harris County, you do your pretrial diversion. If you mess it up, come back, you just go to trial. In those other counties where they dismiss on the front end, one of the things that they have you sign as part of that, a waiver of jury trial. Not all of them,
Not all of them.
but some of them do that. So depending on where you are, that might be a
it
catch.
might affect you, but I mean, but again, it comes back to the problem is not the judiciary on that. The problem is the DA's office and the way they want to run the pretrial diversion program.
Our friends.
Our friends who've been on this show.
Hey, I mean, but what are you going to do? They're the ones who institute the policies. They've got the power.
Did I mention they're our friends, right?
I mean, it's.
I got a lot of friends who do things that I don't like what they do.
And it's
truth.
the consistency of the type of programs that are offered, the consistency of the fear from the line prosecutors from one court to the next of what they'll do and what they won't do is incredible. I think it's actually worse now than it was in the past. You go into one court, you go into court two.
Don't get anybody into trouble.
No, I'm not.
We need good
It's
prosecutors.
day and night. And
We got another call coming in. Hope to God it's a prosecutor calling us to say something. But let's see. Might be Justin again calling to harass us. Hello. Thanks for calling Reasonable Doubt.
which is unconstitutional harassment statute, by the way.
Hey, this isn't harassment if I call twice, is it? Well, but don't you guys think that maybe that part of the frustration I have a lot of times is like when you're talking about little piddly little misdemeanor cases, when you go ask for when the state makes a rec, they don't make a recommendation or for a plea bargain agreement based on the facts of that case. They look over to that thing that Kim has told them to stop writing, and they look at how much time they've gotten on their previous cases, and they make a recommendation not based on the current charged offense and what the breach of the community that the person's accused of doing. They make it based on everything else that person's done in the past. So couldn't what Kim's doing try to be getting at what you guys are complaining about as far as the prosecutors making unreasonable recs and judges knowing about people's past criminal history more than they really should and busting pleas? Does that get to that at all, do you guys think?
So that's an interesting point that Justin brings up. And what he's talking about is, and I know that we've all seen this, but for viewers that maybe don't know, let's say you got a guy who has, he's in on a misdemeanor shoplifting case, Class B, not a particularly rough case, right? But he's got some history. He's got a prior theft. He's got a criminal trespass.
An ag rob he did 10 years for.
Let's just keep it simple. He's just got several little misdemeanors, and one's a theft, one's a criminal trespass, and one's a criminal mischief or something like that. And on the first one, he was 18 years old. He pled out for time served just so he could go home.
In the old system.
In the old system, and he did it, and it was 2 days. And then the next time, he did basically the same thing, but he'd been in there a week, and he got 5 days. And then the next time, he got 7 days, because it just happened to be the number of days that he was there. Now, this time, he's made bond, right? And he comes in, and he's only got a couple of days credit, and they've got him nailed because of his history. He's not qualifying for the retail theft PTI or anything like that. And, you know, another theft conviction isn't necessarily going to hurt him. He's just, let me take a time served and go home. You go to the prosecutor, and they look down at that list, and they say, oh, well, the last time he was here, he did 7 days. I'm not giving him less than what he did the last time. So they give you a rec of 10 days, and they won't come off of it. Well, he's only got 2 days credit. That means the poor guy's got to go back into jail, and now he doesn't want to do that. When you're out, you don't want to go back in. So that's what Justin's talking about. And if maybe they don't look at that, maybe we get a more realistic rec when they look at just that case. Okay, it's a shoplifting case where he stole $105
There's no prosecutor in Harris County that's not going to, if it's not written on the jacket, it's going to take you about another half hour for them to review the TCIC and NCIC, which they're going to have to do to figure out the rec.
I think
That's the answer.
well, and it goes back to.
They're going to judge criminal history.
Yeah.
It's not going to.
I agree.
We're going to be spending more, which is fine, but we're going the case itself in the jail court, for example, or even on bond. You cannot figure out what's going on within that time frame. So what's going to happen is that individual's going to get reset because they're going to have 30 other people that are looking for the NCIC and the TCIC, and that person is going to get reset and it's going to get bogged down. Which
Yeah, but the problem, I mean, you can't ignore people's criminal history. I'm
No,
sorry.
I don't disagree.
As much as I'm a defense lawyer and I'm going to advocate for my client, look, because you can't set aside and look in a vacuum and say, I'm just going to ignore the 10 other cases this guy picked up and focus on his DWLI. Because here's the thing, I can't do that with my kid. I can't do that with my kid. I give my kid 10 different chances, and then it's the same analogy. It's the same freaking analogy. You got a kid who, you know, you give him chance after chance after chance. You're gonna factor that in, even on a little thing that he or she does, and it's the same thing.
If you allow your prosecutors to continue write criminal history on the jacket, we will get out of court quicker. Other than us having to literally go through event cycle at the bench when we're trying to discuss bail or what to do without an agreed recommendation, pragmatically, it will be quicker for every human involved, criminal lawyer or prosecutor, clerk, every person involved that's involved in the crappy process that we have now. It's better if you can please allow them to write criminal history, even though it's crude, OCC, out of county, whatever. We at least have a written down event cycle. Without that, I'm telling all of you, the prosecutor literally has to go page by page, and often it's a half-inch thick.
and they're not going to print it out anymore. And so someone's gonna have to be at a computer.
I mean, look, I had a case recently where
That's incredible.
I had a client who I was able to, 4 years ago, get them a felony pretrial intervention. Okay? And before we could get it expunged, before the waiting period had passed, you know, on everything, they picked up a new felony. Now, you don't think that the DA's office is going to kind of hold it against that person?
Of course.
That, hey, they got a really, really big time gift 4 years ago. And yeah, we hear what you're saying on your mitigating circumstances. Now, thankfully, I was able somehow miraculously to get this one pled down to a misdemeanor.
Because you're a good lawyer.
But it took me forever because, rightfully so, they held it against her that she had gotten a pretrial intervention and had basically done the same thing again.
When the prosecutor gives recommendations, when the government gives recommendations based on criminal history versus the merits of the case, I think that lies the problem. I think they can, I mean, they're going to have to. You have to take in prior criminal history when you're evaluating the case.
Agreed.
However,
That's a different scenario. If it's the merits of the case we're talking about, that's a different scenario.
The problem, though, is what he's talking about is where they ignore the merits of the case.
I agree.
And give a rec based on the criminal history.
We
Because
see
I have
that
that happen a lot where they say,
But
I'm not going to dismiss this because of this.
even though their case is crap.
Yeah.
Yeah, but there's
Yes.
there's nothing you can do about that. That's just when you
Well,
have
set
to
it for
buckle.
trial.
Exactly. So you're never going to change their mind on that. And look, that doesn't happen with every prosecutor.
No, it doesn't.
I will say right now that is a low percentage of prosecutors that pull that crap. The majority of prosecutors do not pull that. Well, I'm not going to dismiss this even though it's a crappy case. Those are the crappy prosecutors that need to be booted out, and that's not the majority of the prosecutors.
It's not
that
the
are out there.
majority. I agree with you. But
There-
there is a handful.
There's a handful out of what 200 prosecutors. In
I'd
that
go so
office?
far as to say a lot of them start that way, and then after they actually evaluate the case, they'll make the appropriate They'll make the appropriate decision.
Yeah.
Yeah.
But it's a terrible starting spot. Not all of them.
Yeah.
Look, not all of you. Not all of them.
Right.
Not all of them.
Dude, we've rambled on for a full hour.
Are you serious? I thought it was like halfway
Yeah.
time.
I know we didn't even get to cover half the other things.
What else?
Huh? Well, I mean, I was going to talk about these bartenders that were charged, but we'll have to save that for another time and place because I'm getting the rap sign now.
Already?
That's quick.
Time flies when you're having fun, especially when you don't come dressed up to the show.
It looks good.
Like you're able to just
Nice and
just
relaxed.
The man has the stage. The man has the honors, you know? I mean,
I just work here. Not actually here. I don't work here.
somewhere else.
I work in Houston.
There you go.
Somewhere.
That's all the time we have for this week, ladies and gentlemen. We appreciate you joining us for this episode of Reasonable Doubt. We will be off next week, I think.
we are off.
We are off next week, so we'll be back in 2 weeks with a new episode and hopefully guests that wear a suit. We'll see. For Todd DuPont, Wade Smith, and Julio Vela, I'm Jimmy Ardwan. We'll see you in a couple weeks, ladies and gentlemen. Good night.